Judge, may I open court?
Please, thank you, Anne.
Thank you, Judge. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-3093, United States of America versus Samira Jabr, appellant. Mr. Kramer for the appellant, Mr. Lenners for the appellate.
Good morning, counsel. Mr. Kramer, please proceed when you're ready.
Good morning, Your Honors, and may it please the court. AJ Kramer on behalf of Samira Jabr. This was an unusual case in the sense that once the government presented its evidence and completed its proof, it became apparent that the information that the government filed, remembering that it was solely in control of the government because this was a misdemeanor, what the information said, it became apparent that Ms. Jabr was not actually charged with a federal crime. She was charged with entering the White House complex and the Treasury building and grounds, which is not a federal crime, as the district court properly found, and as the government does not dispute on appeal. They don't dispute the district court's finding. And if I could read to you from what the government said to the district court, the chart at page 155 of the appendix, they said the charging language specifies the date and location of the offense, the identity of the accused, the required scienter, and the essential facts of the criminal conduct. In the next sentence, they said, it's further specified that she entered the White House complex and the United States Department of Treasury building and grounds, language that informed her of the specific conduct alleged to be a federal crime. So that, since it turns out that was not a federal crime, two arguments. One is the district court should have dismissed the case at that point because no federal crime was alleged in the information. Or second of all, the district court could not have found Ms. Jabr guilty of an attempt to commit what's not a federal crime.
So can I ask you about the first one of those? So,
sure.
As I recall, there was no Rule 12 motion ever filed in this case, right? The motion that was filed after the close of the evidence was a Rule 29 motion?
Yes.
So if there's no Rule 12 motion to dismiss the, if there's no Rule 12 motion to dismiss the information, then we're not dealing with the appeal from what you would say is the erroneous denial of a Rule 12 motion. All we have before us is the motion for judgment of acquittal.
So two things. There was, in the papers for the motion of judgment of acquittal, there was a motion that the district court should dismiss the information because it, after the proof was made, because I didn't think it would have been proper to file a Rule 12 motion in the sense of there was no proof. The government would have said we have to wait because you got to remember the government's focus entirely, almost entirely in the district court was that this did charge a federal crime, that White House complex and Department of Treasury building and grounds was a federal crime, was included in the statute. So in the papers for the judgment of acquittal, it specifically asked said to the district court that it should dismiss the information because it fails to state a federal offense. And the government said that the timing of that was not improper. They specifically told the district court that because a defendant can raise jurisdiction at any time, that the timing of that was it's not the timing, they said, that was the problem.
Well, so that I think that's true of if it's jurisdictional. So, and I know that you have your argument that there was a lack of jurisdiction here, but if we don't think of it in terms of jurisdiction, there's still the possibility of filing a Rule 12 motion to dismiss an information on the basis that a crime's not alleged based on what's spelled out in the information. And that, I think that what one would need to make that kind of argument is apparent on the face of the information, but it wasn't made at the time that the information was issued.
Well, I don't think it is apparent on the face of the information because remembering that the government said White House complex and Department of Treasury and grounds is a restricted area under it. That was, and until there was proof at trial, there was no way to know whether that.
But what if, for example, what if the indictment says, the information said that the area that was breached was Pennsylvania Avenue?
That would be, I think that would be a closer case I mean, that might still there might still be an issue. The government, let me put it this way, if a Rule 12 motion had been filed, the government would have done exactly what it said in the district court, that this White House complex and Department of Treasury building and grounds is a restricted area under the statute. And you can't decide that, Judge, until the facts come out at trial, because this can't be a pretrial hearing. The pretrial hearing would be the trial itself, essentially, about what it is. So that's the reason. But in the papers, it said, during the papers, the Rule 29, it said that the information, the district court should dismiss the information for lack of jurisdiction. And the government said that the timing of that was not a problem. They specifically said timing is not a problem. It's incorrect legally, is what they said. So they specifically told the district court that it's not the timing of the argument that's incorrect, but it's the merits of the argument was incorrect. So I think that's why there couldn't be a Rule 12 motion. First of all, on jurisdiction doesn't have to be filed. It can be raised at any time. And second of all, would have been premature in the sense of it required the proof at trial of the government's witnesses testifying that the White House and its grounds are different than the White House complex and grounds. But even there's still the second issue, which is the district court. This is not a lesser included offense, which the government spends much of its brief arguing. The Schmuck case, one of my favorite names for a defendant, the government spends much of its time arguing that Schmuck applies to this case. It simply does not. It's talking about a lesser included offense. And the government even cites cases in its brief decided long before Schmuck, saying that attempt is a lesser included offense. But
even if we agree with you on that, it seems that the district court relied on Rule 31C2 and said that this was an attempt to commit the offense that was charged. Why isn't that what happened here?
I do agree that that's what the district court tried to rely upon, although the government disputes that in its brief. But that's not because the offense charged, which includes, according to the government, the specific conduct and the essential facts, is not a federal crime. It's just not a federal crime. So you can't attempt something that's charged in she was not charged with attempting.
But she was convicted of violating, what is it, 1752A1, right?
Yes.
And that is what the offense was that was charged in the information, 1752A1, as far as it's the same statutory provision, right?
It's the same statutory provision, but the government never moved to amend it, first of all, either to change White House complex and the Department of Trade. In fact, they specifically eschewed amending the information.
So let's suppose she were charged with assaulting a federal employee, the general assault, federal assault provision, 18 USC 111, I think it is. And the information said that she committed the assault, to which she punched a Treasury Department employee. And then the evidence that comes out at trial is that she punched a U.S. Park official who is an Interior Department employee. And the judge says, well, under 31C2, there's no problem here. It's still the same offense. I'm going to find her guilty. You filed the same sort of motions, Rule 29 motions and whatnot that you did here. And the court found her guilty of assaulting an Interior Department employee when the information said a Treasury Department employee. Would that be a problem?
I think it is. I think on several grounds, it's two different. It's not the facts alleged in the indictment and the information, which I rely upon the Sanders case from the Fifth Circuit that says Sanders argues quite sensibly that the government must prove the crime charged in the indictment, and that permitting the government to convict the defendant on a material different theory or set of facts which I think that is. But even if it wasn't, I think there's a major difference there, because both of the things you've hypothesized are federal crimes. In this case, and White House complex and Treasury Department is not a federal crime.
Well, it could be depending upon the facts, right? If let's suppose the president had, gone to visit the Treasury Department and give a speech and was in that building at the time she jumped the fence and ran up, then that would be a crime, right? Because the way that the statute's written, depending upon whether a protected individual is at that location and you breach it, then it's a crime, right?
It could be, but that's under a different subsection of the statute. That's not under the subsection Mr. Jabr was charged with. That's under 1752 sections B and C, or B, where a protected person is temporarily visiting. That's not the crime Ms. Jabr was charged with. So she was charged with subsection 1A of the White House or its grounds.
No, she's charged with A1, which is entering any restricted building or grounds. That's right, an offense, and there's a definition of restricted building or grounds has different definitions, but it's still the same offense, right? You're still entering a restricted building or grounds. It's just a difference in theory of why it's a restricted building or grounds, right?
Which needs to be charged in the information. What she was charged with was the term restricted buildings or grounds means any posted of the White House or its grounds, is what the government claimed and what the district court convicted her of. But that's not what she was charged with. She was charged with a totally different set of facts.
But when you saw that information, what part of restricted building or grounds did you think that they were alleging?
Well, until the proof came out at trial, we didn't know, frankly, until they said what they claimed was the restricted building or grounds. It was impossible to know.
Counsel, may I ask a question, cutting through some of the technicalities? How were you prejudiced in this case by the district judge's modification? I won't use say amendment. Why were you prejudiced?
Because she was convicted of something that's not a federal crime. I mean, I think if the theory seems to me...
You were notified, of course, that the district judge was focusing on attempt, right?
The district judge was asked a couple of questions about attempt during the argument. I don't focus. I'm not sure I agree with that.
Did you have an opportunity to argue against that?
To argue against? Sure. Yes.
Against attempt?
Yes.
What was your argument?
That you can't attempt to commit what's in its entire case. I don't think we're required to show that for two reasons. First of all, she's convicted of something that's not a federal crime, as the charged in the information, and the government never moved to amend the information. And second thing is... But
the district judge did.
No, the district judge did not. The district judge, I think, may have constructively amended it, which is per se reversible error, a constructive amendment. But the district judge...
Well, we have to distinguish between cases in which involve an indictment that presents a constitutional question and an information. And in Rule 7, an information is given a much greater freedom.
Well, I don't think so in this sense, because the rule says, unless, and it talks about the court may permit an information to be amended at any time. That doesn't say the court can do it on its own. That requires the government to move to amend the information, which it specifically said was unnecessary and it was not doing.
Well, I don't read that as precluding the judge doing it on his own.
Well, I think the court, the rules are written, there's many rules written that say the court, the defendant or the government or the court on its own may. This doesn't contain that. This says the court may permit it. Somebody has to ask for the court to permit something.
So your basic argument then is it was improper for the district judge to affect this modification.
Absolutely. Well, that's a second argument. The first argument is what I said about not being a federal crime. But yes, unless the government moves, there's nothing the district court can do to permit something.
So can I don't want to cut off Judge Silberman. I want to follow up on one of his questions, though.
Go ahead.
On that issue, even if we assume that it's improper to amend the information, for the judge to do it, to amend the information without the government's participation, then why wouldn't harmless error apply? And I'm going to assume that you're going to say harmless error doesn't apply, and I'll want to hear what you say about that. But if we assume that harmless error does apply, what's harmful about the error here?
The harmful, I come back to what I've said. The harmfulness of the error is she was convicted of something that's not a federal crime. I think that's pretty basic, a basic right that people have to be convicted, to be not, say, close enough for government work. That's not the way the criminal justice system works. So I think that's the main prejudice, is she's convicted. The second thing is the government specifically said, we're not asking you, there's no need to amend the information.
But the conduct she was, just on the first one, the conduct she was convicted of, if you allow that it's an attempt, the conduct that she was convicted of is a federal crime. The conduct.
The conduct may be, although there's the whole thing about without lawful authority, which I think
right. Putting that to one side, I know you have your argument on that, but the attempt, the conduct that constituted the attempt is a federal crime, and so then the question becomes what's non-harmless error about allowing an amendment of the information in the way that it came about here. I think an amendment, as opposed to a variance, an amendment of an indictment, and I'm going to say information since the government, is per se reversible error, I believe, as opposed to a variance, which is evaluated under a different standard. I think.
Don't you think those cases all involve the problem of a grand jury circumventing a grand jury, which you don't have in an information?
Well, I think there's all the more reason to hold it to a stricter standard here, where the government drafted the information. It was totally within their control. And they specifically told the district court when the issue arose, no, we're not amending the information. When we don't want to amend the information, it states a federal crime, and they insisted on that. I don't see why rewarding them for that stance is better, so to speak, or different than allowing an indictment to be amended. So that's the one thing. I don't, and Chief Judge Srinivasan, I think there is the issue of if she had actually gone to the White House, and there's much different fencing and signage and Secret Service officers. I don't think that it's clear that she would have attempted to enter there. So I'm not sure that I agree with you, putting aside the without lawful authority, but no evidence of. I'm not sure I agree with you that the conduct constituted the crime of attempt in any event.
Well, suppose she had just crossed Pennsylvania Avenue and never even reached either location, either the Treasury Department or the White House, but she had intended to cross into the White House, and she was stopped. And there's unequivocal evidence that she so attempted. Didn't she commit a crime?
If she was charged with that crime, if she was charged with the
attempt,
but under
what is it, Rule 7? the attempt is always covered by the charge itself? You don't have, the government doesn't have to charge attempt separately, it's included.
If there's an attempt provision in the statute, yes. But it has to be a federal crime that she's charged with to begin with.
Well, suppose she was just walking across the Pennsylvania Avenue.
Well, I mean, there'd have to be a lot of evidence. I don't know how she'd be stopped, but there would have to be a lot of evidence that.
Yeah, well, in this case, the evidence was unequivocal. She admitted it herself.
Well, she said she wanted to talk to Trump, is what she said. She didn't say she was going to enter the White House without lawful authority. She said she wanted to talk to Trump. And the government presented no evidence about, and Judge Silberman, what may be missing from your hypothetical is the without lawful authority part of it. So the government could have asked any of their witnesses, did Ms. Jabr have the lawful authority? And they chose not to for whatever reason.
Didn't they elicit evidence that it was a restricted area? Everything inside the fence was a restricted area?
They did say that, but that doesn't mean they didn't say restricted to who or what. And there were you got to remember where she stepped over the fence and the gate, there were no signs saying anything about restricted area or no entry. Those signs were at a much different location than where Ms. Jabr stepped over the fence. So saying that it's restricted entry also, I don't think proves, the government has to prove beyond a reasonable doubt that she was without lawful authority. Saying that it's a restricted area doesn't prove that Ms. Jabr did not have lawful authority to enter, I think.
Okay, let me make sure my colleagues don't have further questions at this time. We'll give you some time for rebuttal, Mr. Kramer.
Thank you.
We'll hear from the government now. Mr. Lenners.
Thank you, Your Honor. Good morning, and may it please the court, Dan Lenners for the United States. The defendant in this case was charged with the completed crime of entering a restricted area under 18 USC 1752 A1. She was convicted of attempted entry of an unlawful area, of a restricted area under the same statute. That was proper for a variety of reasons. Fundamentally, the defendant has never identified any prejudice as a result in the difference between the crime with which she was convicted.
So can I just ask you, why not ask to have the information amended or adjusted? Once you're at the stage of the case where you've had your chance to argue that the White House the White House complex and Treasury Department count, and the district judge rejects that. So you know that you're in a land in which what's spelled out in the information, if you include the factual statement about the White House complex and U.S. Department of Treasury, doesn't count under the statute, then why not adjust the information?
Your Honor, I don't actually think the timing of the case bears out the conclusion that the government had that opportunity. In its responsive pleading to Ms. Jabr's Rule 29 motion, the government continued to argue that the White House complex, the entire complex, was covered by the statute. As part of that pleading, the government noted that if it believed it was necessary, the court could amend the information under Rule 7E. That's page 138 of the appendix. There was then argument on that motion that also constituted closing argument, at which the defense was given opportunity to present evidence and declined. And then in its written order, the court both resolved the Rule 29 motion and then went on to resolve the merits of the case. So there wasn't this time between when the court rejected the government's statutory interpretation and when it made its final decision for the government to then say, well, given Your Honor's understanding of the statute, you should amend the information. But fundamentally, if the complaint by defense counsel is that the court amended the information, that amendment was proper under Rule 7E. And if there was some error in Rule 7 because the court did it sua sponte rather than upon an explicit motion from the government, that error was harmless. Because again, there's just no prejudice here. The defendant has no factual defense. to the charge of attempting to enter the White House. She believed she had entered the White House when she arrived at the Treasury building's porticoed entranceway, or pillared entrance, and she intended to go there to speak with President Trump. And the defense has never identified, even today, how the defense to attempted entry of the White House would have differed. Certainly, they never sought a continuance when the district court indicated that he believed the government had a better argument for attempt. They had the opportunity to put on evidence at a time when the government had already filed a pleading saying to the court, you should find the defendant guilty of attempt. And so fundamentally, it's harmless. The court could also say it was an appropriate amendment under Rule 7E, or the court could say it was an appropriate conviction for attempt under Rule 31C. But anyway,
31C what?
31C2, Your Honor, is our view. The crime charged was a completed violation of Section 1752A1, and the crime for which she was convicted was an attempted violation of Rule 1752A1.
Counsel said you disputed C2, but I didn't read your footnote as saying that.
I didn't say that it wasn't C2, Your Honor. We merely said that the courts seem to lump these together, and the district court here wasn't entirely clear that it was proceeding under that ground. And so if for some reason, by narrowing the factual allegation from White House complex to White House grounds, the court was convicting of a necessarily included offense under C1 or C3, that was appropriate as well. But it seems that legally the cleanest path is to say that the court found the defendant guilty of an attempt for the same statutory provision with which she was charged, and thus this was proper under 31C2.
Let's suppose what happened is that the defense had raised this as an issue potentially, and so the government reopened its case and put on the evidence that just before the incident at the Treasury building, she had gone to the vice president's residence and tried to climb the fence there and was chased off and got in her car. And then that's when she went to the Treasury Department. And then the government said she should be found guilty of 1752A1 because she attempted to enter the vice president's residence, and that's a restricted area. Would that be okay?
I think there, Your Honor, there's potentially a due process notice problem, but not necessarily a Rule 31 problem. I think they're conceptually distinct. And so there you might say that there was a lack of notice of the facts alleged and therefore due process violation, and the court wouldn't even need to get to whether Rule 31 was complied with. But here there was no lack of notice issue because the defense was on notice, both of the factual allegation that she entered the White House complex and the White House grounds is entirely subsumed within that, as well as the fact that in the charging document, in the complaint under which she was arrested, all of the facts set forth that were ultimately proved at trial were alleged, which was she went into this restricted area with the intent to enter the White House to speak with President Trump. And so I think that's distinguishable.
When did the government first argue that she was guilty of attempt?
I believe that the government raised the prospect, although I'm not 100% certain, orally during after the defense filed their written motion for judgment of acquittal, or Rule 29 motion. as the government noted at the time, that was a legal issue that they had clearly prepared in advance and that should have been brought under Rule 12 before trial. I believe orally the government in August of 2018 at the Rule 29 stage mentioned that she could be convicted of attempt. Certainly the government briefed it in its responsive Rule 29 pleading, to which the defense both had a reply brief and then had the opportunity at the September 13th hearing to put on evidence. And the judge gave them two opportunities, both at the beginning and at the end of the hearing. And both times the defense declined to put on evidence, declined to have the defendant testify and arrested. And that's because it's apparent that there is no factual defense to this defendant's attempted entry of the White House. And so this was a legal defense that fails, whether it's under Rule 31, Rule 7, or because ultimately any error would be harmless.
So just so that we're clear, your position as to how we are supposed to construe the language of Rule 31C2 in attempt to commit the offense charged is that we should consider offense charged to be whatever the statute is, in the factual basis for the offense is irrelevant to how this rule should be interpreted?
So I think that's one interpretation of Rule 31C2 that we've proffered based upon the Schmuck case, which focuses, again, it's a different subsection of 31C, but which focuses on the statutory elements in deciding whether something's necessarily included. It seems like Schmuck suggests that the appropriate focus for the court is on the statute charge, not on the facts. But if the court disagrees and thinks that the factual allegations are also encompassed within the offense charged, we still think that Rule 31C2 is satisfied here because the factual White House or its grounds is completely subsumed within the White House complex that was charged. And thus, under Miller, the court can, courts, it's not a variance to find the defendant guilty of factual allegations that are narrower than those.
So let me ask you the same hypothetical I asked Mr. Kramer. Suppose she was charged with assaulting a federal employee, namely punching a Treasury Department employee, but then the evidence at trial that convinces the fact finder here, the district judge, is that she actually punched an Interior Department employee, a park police official. No problem finding her guilty of that when that's not what was alleged in the information under Rule 31C2?
I'm not sure it's a Rule 31 issue because there's no attempt or necessarily included offense. I think there's no problem there because it's a variance and not a construction.
Well, it's a Rule 31C2 because she's found guilty of assaulting a federal officer. It's just not a Treasury Department officer. It's an Interior Department officer. So she's found guilty of the same statutory offense, assaulting a federal officer.
Yes, Your Honor, but Rule 31C2, it has to be attempt, which is why I said I don't think it's a Rule 31C2 problem. Ultimately, I think it's a variance, but not a prejudicial variance, not a constructive amendment, because the identity of the federal officer charged or the department for which the federal officer works is not a necessary element of the statute. And so the court could, vary from the information by ignoring that part of it or, striking it as surplusage. It's like in felon in possession cases where the government alleges that the defendant possessed a certain type of firearm and the evidence at trial establishes that, we charged the wrong firearm. It was a 45 instead of a 22. And the cases are clear that that type of surplusage can be struck from the indictment because it is surplusage. It's not necessarily to the crime charge. I think that answers your hypothetical, but I think that's a different case than we have here. But if the court is struggling with the Rule 31 issue, it seems like regardless of whether the government expressly asked for a Rule 7E amendment, that's fundamentally what the defense is arguing, that this was an improper amendment. And Rule 7E makes clear that because the grand jury right doesn't apply to informations can be amended so long as that complies with the due process notice right. And for the reasons we argue in our brief, this defendant was on ample notice that she would have to defend against an attempted violation of the statute charged of the White House that's subsumed within the White House complex.
Okay. Let me make sure my colleagues don't have additional questions for you. Thank you, Mr. Lenners.
Thank you.
Mr. Kramer, we'll give you 2 minutes for rebuttal.
Thank you, Your Honors. Several points. First of all, the government's claim that the factual basis is irrelevant, as I get it, was never made in the district court or in their brief. In fact, in the district court, they said just the opposite. As I said, it includes the essential facts of the conduct and informed her of the specific conduct alleged to be a federal crime. That's at page 155. I want to say about the amendment to the indictment. At page 138 of the appendix, they said there is no need to amend the information in light of the authorities discussed. And they said it is entirely unnecessary to amend the information because of their argument that the White House complex and Treasury were restricted areas. I'd also like to point out at page 194 of the appendix, they said subject matter jurisdiction can be raised. This is the government. Subject matter can be raised at any time. The problem with the subject matter jurisdiction that they made a couple of days ago to dismiss the charge is not the timing of it. It's that there's no basis for it legally. So they were not arguing that the timing of it was improper. And then perhaps the most troubling thing is the government just said a finding under either C1, Rule 31, C1 or C3 would also be appropriate in this case, which could also uphold the district court. And that's just completely incorrect because the Supreme Court in Schmuck was talking about lesser included offenses, which the Supreme Court made clear in Carter meant lesser in terms of magnitude and punishment. So it can't be C1 or C3, contrary to the argument, because those, it's not lesser included in terms of punishment in this particular case. So,
but they relied on C2. That a footnote indicated maybe C1 and C3 would apply too, but they relied on C2.
No, I'm not so clear since they just said in argument it's also proper under C1 and C3. But I think the district court relied on C2, absolutely. I think the district court said the government has not asked. The district court specifically said, I note that the government has not asked to amend the information. And I think the district court was relying totally on C2. But you cannot attempt to commit something that's not a federal crime, which gets back to the main argument in any event. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Could I have a moment?
Sure.
Tricia?
And why don't we take just a quick recess?
This honorable court will now take a brief recess. Judges, give me 1 minute while I put everybody back in the waiting room.
Sure.
Thank you very much. Case number 20-5163, Overdevest Nurseries LP, appellant, versus Eugene Scalia in his official capacity as United States Secretary of Labor et al. Mr. Lake for the appellant, Mr. Goldsmith for the appellees.
Mr. Lake, please proceed when you're ready.
Good morning, and may it please the court. My name is Monty Lake, and I appear on behalf of Overdevest Nurseries. The issue before the court this morning is the validity of the Department of Labor's 2010 corresponding employment rule under the Supreme Court Chevron standard and the Administrative Procedures Act's arbitrary and capricious standard. In 2010, the Department of Labor changed its rule on corresponding employment to basically state that any work, any task performed by a U.S. worker that was the same as an H-2A foreign worker deserved to be paid the same adverse effect wage rate. This was a significant departure from the rule that had been in effect for 21 years since 1987, issued contemporaneously with the Immigration Reform and Control Act of 1986, that used the statutory language occupations as a standard against which to measure whether or not there was corresponding employment between U.S. and foreign workers. This change was made in 2010 with a statement that the department was really returning to the 1987 rule, because there had been a brief interlude in 2008 when the rule is essentially the same except for two problems that the department had a problem with, one of which was the allowance of incidental employment outside of the job description approved by the Department of Labor. It corrected that problem in the 2010 rule and eliminated it, but then went on to use the any work standard. Our view, and we believe the law supports the fact that this change is not an interpretation of the statute. It is really an amendment of it because it takes out the able, willing, and qualification standard of the law. Overdevest, unlike many in agriculture, has very
Can I
highly—
ask you a question that's about just to understand your argument and the claim. Is it your contention that removing in the occupations or in the same occupations, removing that language did anything different or in addition to adding the in any work language?
Well, the occupation is what the Department of Labor, when it looks at a job order, an application to participate in the program, it's the gatekeeper. When it looks at the occupation, it is looking at all the duties described in the job order, the skilled duties in the case of Overdevest order pullers, or it can be a farm that has pepper pickers, and that's all they do, in which case everyone does the same thing. That is an easy judgment to make. When you have the situation with Overdevest, where you have individuals who have to identify over 2,000 varieties of plants and then match them with their Latin botanical names from customer orders, this is highly skilled work. And so different occupations are different. The statute talks about occupations or crops.
Counsel, before you go into the policy arguments you're making, isn't it crystal clear what the actual operative language of 2010 says, the 2010 regulation? Put aside the preamble, the reference to job order. Isn't it crystal clear what the actual operative language of the 2010 regulation says? You may argue that it's improper for one reason or another, but it is crystal clear, is it not?
Yes, the language is clear. It says any work, and we did not argue under our that there was ambiguity as to what the
let's put aside the preamble, which is really not relevant. Okay, so we can accept then the language is clear. You were on notice as to what the language said. Your argument is somehow it's inconsistent with the statute or somehow arbitrary and capricious. but there's no question you were under notice.
Well, the rule was there. Our client was not aware that the rule had changed. And in fact, he had
that and 10 cents gets you on the trolley car. If the client didn't hire a lawyer to read it, that's his problem.
Well, Your Honor, I agree with you that the language of the rule is clear. The question is whether, as it was applied to our client, and the first time he was aware of it, and he had basically had the same job order approved by the department for 12 or 13 years up until this point, it's his first opportunity to challenge the legality of the rule itself based on the statute.
But I want you to eliminate any question of notice because it's irrelevant. The regulation was crystal clear, and if your client didn't hire a lawyer to read it for him, that's no excuse. So why don't you just eliminate that from the argument?
Well, our argument, our point we go to is that the Department of Labor approved this job order from 1999 through 2012. And there was no enforcement action taken against it based on it.
But again, that and 10 cents gets you on a trolley car. The question is what the regulation means and were you on notice of it? And the answer to both questions is yes. It's perfectly clear what it means and you were on notice. So the fact that a Department of Labor official before that regulation was unclear as to what the meaning was is irrelevant.
Well, the question, Your Honor, here, though, is whether or not it withstands scrutiny under Chevron and the Administrative Procedure Act in terms of being a violation of the statute upon which it is based. And our argument is very simply is that if you look at the statutory language, which states basically we have two provisions here. We have the able, willing, and qualified, which has been written out of the statute by this regulation, and we have the similarly employed U.S. worker language. The common thread between both of these statutory phrases is labor or services. The labor or services in the similarly employed language upon which the department relies references that in able, willing, which references the petition, and the petition is accompanied by the job order and application with the specific duties specified by Overdevest, and in this particular case, and it was certified and approved for 13 years up to this time by the Department of Labor before this issue was raised. And we believe very strongly that
But counsel, I keep going back to what the situation was before the regulation was passed, and I keep saying to you, and I don't understand you to say anything different. It's irrelevant.
Well, the question is whether or not the statute can withstand scrutiny in terms of the rule under the provisions of the statute. And that has been our argument in this case, that it is not, it's not. The language able, willing, and qualified has to mean something. And
yes, it's something for the first section, but not the second section.
But they are interrelated. The department has made the argument, accepted by the district court, that the rule in this case, is based upon the similarly employed language strictly. They believe that the qualification language is irrelevant, but their purpose they rely upon is protecting U.S. workers, and they ignore the adequacy of the labor force, which was the other purpose, which in Dole stated had to be balanced. You had to look at both of them, and you can't justify the effect of its rule. The effect of this rule is as discrimination. It separates those who apply and are not qualified, who do not have to be hired and paid anything, and those who...
I don't read it that way, counsel. I don't read the adverse effects section, the second section of the statute, as tied to the first section at all. The first section asks the question, are there available workers to do this job? The second question is the second statutory section says, even if there are, there should not be an adverse effect on them. Even if there are no able, willing workers available to do this job, nevertheless, we wish to protect against adverse effect. An adverse effect to conditions as well as wages. And if the foreign workers perform work that would otherwise be performed by domestic workers, that hurts them. That takes away their job opportunities.
Well, Your Honor, that's not the case here, because you had highly skilled workers who did the substantial majority of their job doing these highly skilled tasks. And
yes, and insofar as they perform any other task that would otherwise be performed by domestic workers who are not able, willing to do the highly skilled work, insofar as they're doing that work, they're taking it away from the domestic employees.
well, two responses to that. Number one, the client was doing what the Department of Labor wanted them to do when it attacked the 2008 rule, which basically the department had a problem with the incidental employment, and the client put that.
I do not understand, counsel, why you keep going back to 2008. The question is what the 2010 modified regulation means.
And I was trying to respond to your question about whether or not the similarity in doing a few minor tasks in common was adversely affecting them. And what the Overdevest was trying to do was what the department wanted them to do, was have full disclosure in their job order when it was advertised for domestic workers to apply for the job. And because there would be times when there would be overlap in the duties, when they essentially are working as a team in the workplace, they wanted to protect themselves from debarment. And that is a specific provision in 2008 that the department eliminated. Our client was doing exactly what they wanted to do since they entered the program in 1999. They were doing exactly what the department wanted them to do. And the department approved the job order that had the incidental duties in addition to the highly skilled occupations along with it. So we don't feel we were adversely affected. We're doing what the department approved that we could do.
Make sure my colleagues don't have further questions for you at this point. Mr. Lake, why don't we hear from the government? Thank you. Mr. Goldsmith.
May it please the court, Aaron Goldsmith on behalf of the government. As the district court recognized, this is a classic Chevron case. In this case, Congress created the H-2A program and delegated authority to the Department of Labor to make policy choices and to design the rules implementing and governing this program. Significantly, Congress did not define the terms adversely affect or similarly employed, but rather left it to the agency to fill in those gaps and to accomplish the two goals of this program of protecting U.S. workers, but also allowing employers to bring an adequate supply of labor. And that's what happened here. In 2008, the agency made one policy decision to limit the scope of corresponding employment to newly hired workers. In 2010, the agency made a different policy decision, deciding to remove that limitation and to further expand the scope of corresponding employment to include work that was performed outside of the job order. There was nothing irrational or improper in the agency making these policy decisions. And I would add—
Now, counsel, would you say that the scope of the 2010 rule is broader than the scope of the 1987 rule?
In one respect, in one substantive respect, and that is with respect to work performed outside the job order. With respect to this idea that the 1987 rule was limited to only qualified workers, that's simply not the case. And as the preamble to both the 2008 and the 2010 rule set forth, they're carrying forward the old requirement that that the adverse effect wage rate be paid to any domestic worker performing any of the same task, any of the same work. And I think the agency went a little bit beyond that in the preamble to the 2010 rule in explaining exactly that this is not a new requirement and tracing with citations to the Federal Register this requirement in previous rules and previous programs going all the way back to 1967. Now, that's not directly applicable here, but the point is this is not a new requirement. We set forth the the agency handbook, the Hyatt forms.
But didn't the agency in 2010 imply that it was essentially the same rule as 1987 when that's not really the case?
Well, it did expressly state in the preamble that it was making this change for expanding it in terms of any work performed by the H-2A worker in the agricultural capacity. That is, even if the work was outside of the job order, and it explained the reason for doing so. And the district court recognized that and set that forth in the district court opinion. Now, so there was a change. It was not identical to the 1987 rule, but it explained that change. And moreover, I think, agencies sometimes use different terminology, different words, and the fact that the two rules don't have the identical words is not dispositive. And the agency has sort of set this forward, has explained it moving backwards. And I would also add, we're not writing on a blank slate. This court addressed a similar issue in the Dole decision, where it said, look, Congress has not defined what adverse effect means. That case dealt with the methodology for the adverse effect wage rate. It was a policy decision. It was within the bounds of a rather broad congressional delegation. And this involves a similar issue, although not an identical issue, of to whom that adverse effect wage rate must be paid, to whom is it owed. And the reasoning applies here. There was a change, but that change was explained. There's nothing improper about an agency changing its mind or determining, look, we need to take additional steps, additional measures to protect you.
Thank you. I mean, one of the other things, though, that was changed in 2010 was the language about occupations was removed, same occupation. But I don't recall seeing any reference to that change in the rule, and that was raised in the opening brief, pages 43 and 44, I believe, of the opening brief. And I didn't see any response to that in your brief. Did I miss that in either the rule or in your brief, as far as any explanation for why the occupations language was taken out?
So Your Honor is correct that the occupations language was taken out, but the agency never defined in that regulation what occupations means. Its position and its understanding that was set out in the preamble to the 2010 rule is that if it was any work, you had to pay the adverse effect wage rate to those U.S. workers. So, so that, it is true that it used the word occupations, and that word does not appear in the 2010 rule. We concede that point, but the agency didn't. This isn't something where there was no explanation. It traced that requirement back through different rules, even though the program has changed considerably over the years, and there have been all kinds of changes. The terminology has not been the same. This requirement has remained the same, with the exception, with limited exception, for the period of time from 2008 to 2010, when there was this additional limitation to newly hired workers. That was, if you look at the 2008 preamble, that's what they're saying we're changing. And then in 2010, they're explaining why they're removing that limitation, that it proved to be unworkable, that they look at it, and there were these anomalies produced by that rule. So that was kind of the reasoning, and that was what was set forward. And I think the judge the district court judge hit the nail on the head, and this is on page 412 of the joint appendix, in terms of looking at the different rules, whether it was the 1987, the 2008, the 2010, that none of them restricted it in the manner in which the plaintiff suggests, and that under any of those, it's not limited to workers having the same qualification. Rather, it's any work, with the exception of that one limited exception that I just discussed for the period of time from 2008 to 2010.
Can I understand something, I guess just kind of factually, in how this program works? Or the H-2A workers paid the adverse effect rate for everything that they do, whether it's the kind of what's specifically in their qualifications, or in this case, when they are doing the other agricultural or any work, they're paid the same wage rate for all of it. Is that correct?
I believe that's correct, with one caveat. The H-2A program creates a wage floor, and there are some circumstances where that floor is above the rate of the adverse effect wage rate. But for the purposes of this case, the wage floor is the adverse effect wage rate.
Wait a minute, counsel. I misunderstood that. I thought, from reading the briefs, I thought the domestic workers would be paid at a higher rate, the adverse rate, for work it performed that was identical to the work performed by the skilled workers, the skilled workers in the non-skilled task. In other words, I didn't understand, maybe I have it wrong, I didn't understand that if the skilled workers perform, say, 20%, spent 20% of their time on unskilled work, that the unskilled workers would get all of their pay at adverse levels. I thought they would only get pay for the kind of work that was unskilled that the foreign workers did.
I see my time has expired. May I just address that question?
Yeah, of course.
So they're to be paid the same wages for the same work, is the short answer.
That's what I thought, for the same work. For the same work, not for all their work. For the same work, not all their work.
For the same work, and that's why the district court's ruling was correct and should be affirmed.
But I thought aren't we talking about two different things? Maybe I'm misunderstanding, but I thought what Judge Silberman is asking about is the wages for the similarly employed. And for them, they get the adverse effect wage for work that's the same as that performed by the H-2A workers. But I thought, and they don't get the adverse effect wage for other work. They only get it for the work that's the same as the work that's performed by the H-2A workers. But I thought Judge Wilkins's question was about the wages paid to the H-2A workers. Maybe I misunderstood.
I think Your Honor, I apologize. I think I misunderstood Judge Wilkins' question. So I apologize to Your Honor for misinterpreting what you were saying. But be it as it may, that's how the program is structured as it's set forward. And I think the district court judge hit the nail on the head.
Yeah, so Judge Srinivasan is correct. I was trying to get at the issue of, let's suppose the skilled H-2A worker does 80% of the kind of work in the specific qualifications, but 20% of their work is unskilled work that domestic workers also do. My question is just simply, they get paid that adverse effect wage for the 20% the same as the 80%, right?
Well, the answer is whatever was in the job order, whatever the employer certified that they were going to pay. But it would be the adverse effect wage rate in this particular case.
Okay. So one of the things I'm trying to understand, and help me if I'm a little thick here, is why it would be in the employer's interest to have them, at least economic interest, to have them do work kind of outside of the skilled work, for lack of a better way of putting it, if they're got to pay these foreign workers a higher wage than domestic workers to do the same work. Why is that kind of ever in their economic interest to do that?
Well, employers have to make different decisions, business decisions, based on kind of the realities that they're faced with. And, you know, there are situations where, and I think this is something the district court was alluding to, you might have a situation where you might, well, I'm not sure how else to put it, that you might have situations where they make decisions based on the work that's available, what needs to be done, and they make those decisions, and that's simply.
Let me put it this way. I think there's discussion in your brief of a hypothetical situation where really there's only enough skilled work for 8 employees. But instead of only hiring 8 of the foreign H-2A employees, the company might hire 10 and basically kind of use that extra capacity to have those H-2A workers doing work that U.S. workers could be doing. And we don't want that to happen. We want to protect jobs of U.S. workers. That makes sense if they would be paying the foreign workers less than what they would have to pay U.S. workers. But I don't really understand how that makes sense if they got to pay the foreign workers more than what they have to pay U.S. workers.
May I try and answer that as a former labor official?
Well, I guess so. I was wanting to see counsel's answer, but
all right, go ahead.
I was hoping that you were going to throw me a line there. So let me just say, the concern is that there are these 2 provisions, subsection A and B, and A concerns this idea that you don't want to have a situation where someone has to certify that there is no qualified domestic worker for a position, and then the fact that an employer might say, well, I would prefer to hire a foreign worker for whatever reason is not acceptable under subsection A. And then as to why they might do this, I don't really want to speculate more than what we had said and what the district court identified, that you might have this situation where businesses, for whatever reason, make the decisions that they make.
Let me ask the question this way to follow up on Judge Wilkins. Here's what I understand would be the economic incentive on the part of the employer to get around the regulation. He wants to hire skilled workers, but he knows that, say, 10 or 20% of the time, they won't be occupied on skilled work, and they would like to be able to take incidental, unskilled work. Otherwise, they would just be sitting around doing nothing, and that's not very economical. Now, when they do that non-skilled work, of course, they're paid, even under the old system, higher wages. But it's still worth it to have them not sitting around, because that's a dead loss. But when they do perform the unskilled work, they're taking it away from the unskilled workers. So they're adversely affecting their labor conditions. So that's what I understand the regulation as meaning. Am I not correct?
No, that is one scenario. So, for example, under the facts of this case, there were 55 foreign workers. Perhaps you could have had a situation where they had only brought over, 52 foreign workers, and there would have been additional work for U.S. workers. So that's what we're getting at.
Yes, of course. So the Judge Wilkins asked a very good question. What is the economic incentive for the employer to have the skilled workers doing unskilled work? And the answer is it's incidental, and they don't want the employer doesn't want them sitting around. So he would like them doing that work. Now he will pay a high rate for that, but it's better than they're sitting around. And when they do that work, they adversely affect the domestic workers because they take away some of their job, some of their work. And it's not just wages, it's conditions. Now, am I not correct?
No, that's correct, Your Honor.
Thank you. That helps me understand better.
Unless my colleagues have further questions for you, Mr. Goldsmith, we'll give Mr. Lake his rebuttal time. Thank you. Mr. Lake, we'll give you 2 minutes for your rebuttal.
Thank you. To answer several of the questions just posed, the H-2A workers are paid the premium wage rate for all the work that they do. There is no incentive for an employer to bring in H-2A workers as a cost-cutting measure. They pay for free housing. They pay their inbound and outbound transportation costs, in addition to the elevated wage. The back wages sought in this case are for the entire period that the non-H-2A production workers who did not have the skills coincided employment with the H-2As. It is an absolute practical impossibility to go around the workforce and look at what every person is doing at one time and measure in minutes exactly when there is an overlap in duty. The reason the incidental duty language was put into the occupation of order puller was to avoid the problem, as I mentioned, the department was so concerned about and eliminated in 2008. That was the reason it was done. The client wanted to have full disclosure. When there are times in a dynamic agricultural workforce where people are working together as teams to do things, whether it's pulling plants, putting them on trucks, filling out the orders, comparing them to what the customer wants, it would be an absolute impracticality, as suggested in the brief before this court by the department, to go around and having teams with stopwatches, measuring activities that each is doing. The preamble to the 2010 rule says the intent by going to any task in common as opposed to an occupation, the statutory language, was not to bring the entire workforce into the adverse effect wage, but that is exactly what has happened here. They have basically created an impractical situation which is impossible to comply with in the nature of a workforce. And the department in the preamble of this rule acknowledged that when they looked at qualifications for jobs, their intent was not to micromanage and tell business operations how to run their businesses. And that's exactly what has happened here. And the department, as we stated in our brief, and as their expert in countrywide, Jim Mooney, on this program, who did the audit, conceded it's pretty much impossible for in an ag workforce to basically not have people doing the same thing at the same time on some occasions. And he talked about it. It was characterized as a catch-22.
Okay. Thank you, counsel. Thank you to both counsel for your arguments. We'll take this case under submission.
Case number 20-1058, Western Coal Traffic League petitioner versus Surface Transportation Board and United States of America. Mr. Slover for the petitioner, Mr. Light for the respondents.
Mr. Slover, please proceed when you're ready.
May it please the court, my name is William Slover, and I'm appearing here this morning on behalf of the Western Coal Traffic League. The Traffic League is a voluntary association of electric companies which pay the railroad hundreds of millions of dollars each year for transportation services. Before I turn to my contention that the Surface Transportation Board has made a decision which enables the railroad industry to overcharge my clients millions of dollars, I'd like to address the points which the court raised in its recent orders, namely the questions of mootness and redressability. As the court noted in the recent American Fuels case, an STB case, a case can become moot where an intervening event makes it impossible for the court to award the relief that the petitioner seeks. The event that the court noted was a letter from the Surface Transportation Board indicating that its membership had been expanded by 2 new members. The fact that the board has now 5 members as opposed to 3 or 2 or 1 as it has in the past, the board's membership has over the years been a continuously changing dynamic, does not affect the mootness rule, and we do not see the addition of these new members making our case moot. The redressability question is addressed at page 21 of our brief. Redressability is an element of standing, and it essentially requires or it dictates that the court that a successful decision or a winning decision from the court will redress the injury that we're complaining about. And here again, the injury that we're complaining about, namely the failure of the board to issue a rule eliminating its so-called safe harbor practice, will definitely solve the injury that we're complaining about. So as to both mootness and redressability, we don't see them impacting our petition.
Suppose Congress had passed a new law last week or a month ago, setting up the agency run by a single individual. Would the case be moot?
No, because actually there's a law on the books, Your Honor, that says that the agency, the work of the agency cannot be impacted by vacancies. And it was, the law came about because for many years there was only 1 member of this agency. So I do not see that that would impact the question of mootness.
You don't think it would be moot if Congress passed a new law saying this agency will be run by an individual?
You mean by one board member?
One person.
One
like,
person.
CSP, whatever it is, CSP.
No, I don't. I don't think it would be moot.
Well,
it's an interesting question, but as I say, I don't see how it would moot our claim.
Now, in terms of redressability, we have in a prior case remanded back to an agency when they were deadlocked to explain the positions to indicate there was a deadlock. But in this case, they've already done that, haven't they? What else can we do as a court?
Well, that of course is the basis of the argument that I will get to, namely the decision of the board, we contend, is arbitrary and capricious because it failed to examine any of the evidence, any of the relevant facts, any of the information adduced by the public. And so
that's going to, I guess, the merits of your case. I'm just talking about redressability. What kind of order do you visualize this court could give that would give you relief?
Well, we would analogize our situation to the situation which the court dealt with in the radio and TV case.
Yes, that's the case I was just talking about.
Right, where it remanded the case to the Federal Communications Commission with instructions to provide reasoning and analysis that comported with the Administrative Procedure Act. That's what's missing here.
Well, you do have an explanation from the three members indicating the three different positions and why.
Well, they have three positions, but their basic position, which is before the court, was they're unable to form a majority. Their individual reasons, some of them are wildly misplaced, but they are really not part of the decision as we understand it. And as the
well, my point is they've done what we once before remanded to get them to do in the radio television case.
Pardon, I missed the first part. I'm sorry.
They've already done what we remanded an agency to do.
Well, I respectfully disagree. What they set out to do was determine whether overcharging for fuel was an aberration or an ongoing thing. They made no effort to consider any of that. They failed to consider any of the evidence, any of the submissions by the parties. That had they done that, it's very probable that they would have come up with a rule.
As I read the three positions, at least two of them would have come out, even if they thought that was an aberration, they still would have disagreed as to what to do. So it looks to me that the aberration is just a subordinate question. It's not the major issue, because they were still in disagreement.
Well, I certainly don't agree with you, Your Honor, that it's a subordinate issue, because it's what the entire case was about. If in fact the railroads were not overcharging on a regular basis, then there would have been no need to issue a rulemaking. So the focus of the proceeding, the very reason the proceeding was instituted, was to determine whether continual overcharging was a phenomenon or something that happened all the time. And this was never taken up.
To go back to the mootness, would it be fair to say it's now at this point wholly speculative as to whether there would be a deadlock with 5 members? A little hard to imagine.
I think that they deadlocked with 3. They could have been 3-0-1. So giving them 2 more members, I believe it would be speculative. Yes.
Well, if it's speculative, then it's moot, isn't it?
I don't. No, I don't. I see that if the court were to remand the case with instructions to.
I thought whether it's speculative goes to standing, not to mootness. But am I misunderstanding? And speculative goes to redressability, right? Is that typically how it's thought of? If it's wholly speculative, then there's no standing.
Right.
Well, I would think, to my esteemed colleague, that speculative would be also relevant to moot, because it's a likelihood of an incident recurring. And if it's wholly speculative whether an incident would recur, it would still be moot. You'd have to have some likelihood of the issue would recur.
Yes, if we're talking about the capable of repetition
That's what
idea and mootness. Yeah.
what I'm talking about.
Well, my time is very brief, but as I say, given the nature of the decision we're appealing, my argument is very brief, and that is that the board has rules and regulations on fuel surcharges, and they've been controversial, and they have provided that a charge that includes an element of profit is an unreasonable practice. On the other hand, they also have a rule that says if the charges are calculated using a index published by the Department of Energy, then they are immune from challenge under their so-called safe harbor provision. And a major agricultural shipper challenged the fuel surcharge, demonstrated to the board that the railroads were charging $181 million more than their fuel costs on agricultural products. The board agreed with that conclusion, but it also found that the charge was lawful because it was computed using the public index.
So can I follow up on one question that Judge Silberman asked about, and this goes to redressability rather than mootness for these purposes.
Right.
If the board tells us that it's deadlocked, and we have statements that indicate that the individual members gave consideration to what was presented to them, but at the end of the day they're deadlocked, then it's unclear to me what we're supposed to do, because the board has already told us it's deadlocked. And so if we do something and send it back, we're sending it back to a deadlock.
Well, that I obviously have not been sufficiently clear. Our view is that if the board had performed in accordance with its duties under the Administrative Procedure Act, it would have found from this evidence that the railroads were continually overcharging for fuel. They made no effort to review the evidence. If they had reviewed the evidence, they could not have been deadlocked because their own rules make it unlawful to overcharge for fuel. So our position is very simple. Had they rolled up their sleeves, reviewed the evidence, given consideration to the public comments, which showed thousands of pages of evidence and documents illustrating the overcharging, then they would not have ended up deadlocked.
So your position is that this case is like radio television in the sense that the board identified something that appeared to be a serious problem, which is that even though it had blessed this safe harbor use of an index, nonetheless, railroads were able to significantly, to the tune of hundreds of millions of dollars, overcharge for fuel, and that the board acknowledged that that was a problem, wanted to see whether it was a pervasive problem, because if it was, then that would, justify and necessitate a rulemaking, but that they didn't even kind of get the first base or even do kind of the preliminary work needed, because it didn't even answer that question. It didn't even answer the question as to whether this was a pervasive problem. And if they had answered the question, then that might have spurred them to work harder to try to come up with a solution. Is that your basic argument?
That is better stated than I could have stated it, Judge Wilkins. Thank you.
Okay, my colleagues don't have.
On.
Well, let me make sure my colleagues don't have further questions for you at this time, and if not, we'll hear from the board. Thank you, Mr. Light.
May it please the court, Eric Light, attorney for the Surface Transportation Board, here on behalf of the board in the United States. Today, I plan to address the two issues that were the subject of this court's recent orders, mootness and redressability. As to mootness, now that the board is up to 5 members, it would appear that the case is moot, essentially. This court has said that a case is moot when, no matter how the court rules, it cannot affect the rights of the parties. And that seems to be the case here, because the league at this very moment has the right to come back before the board and file a new petition for rulemaking. Even if this court were to rule against the league, it could still get back before the board and raise the issue of the safe harbor.
But isn't the standard of review for the denial of a petition to initiate a rulemaking more deferential than the standard of review that we have before us now?
I don't think so, Your Honor, because what we have before you now is the denial of or determination of an advance notice of proposed rulemaking, which is a highly preliminary stage of the proceeding. And it doesn't seem like it would be that much different from the denial of a petition for rulemaking.
Well, there's case law, the Consumer Federation of America case, among others, that says that the standard of review that we have now is somewhere in between the extremely deferential standard that we give to the denial of a petition to initiate a rulemaking, and the standard that's less deferential that we give when someone is challenging an actual rulemaking. What we have now is somewhat in between there. And so if you're saying that this is moot, because if you assume that that's correct for the purpose of this question, this hypothetical, then they're not in the same position if they have to file a new petition. They're in a worse position, right?
I think as to the standard of review, you may be right on that, Your Honor, yes.
And even apart from the standard of review, wouldn't their position just be, look, we just want the advance, there's already an advance notice of proposed rulemaking on the books. We just want that to be completed. That's different from starting all over with a petition for a new, from ground zero with the petition for rulemaking. What we want to do is just to have the ANPRM come to a conclusion. It's already started. There's already comments on the books. Those comments should be have been taken into account. So there's a difference between your point that they can always file a petition for rulemaking and their point, which is that we want what's already been done to be brought to a close.
There is that difference, Your Honor, but I'm not sure it's that much of a difference. They basically want the board to rule on the question of the safe harbor, whether or not it should propose the repeal of the safe harbor or not. And it can get an answer to that question either route. That's all the respondents are saying as to mootness. As to the question of redressability, much of what we said in our brief in terms of the reasonableness of the board's decision also applies in terms of the question of redressability. Here, the league has failed to show that the board's decision not to propose the repeal of the safe harbor would have changed anything that the 3-member board did. For example, the league does not claim that this court could have ordered the board to propose the repeal of the safe harbor, nor has the league explained why a remand to consider the aberration issue would have changed any of the 3 board members' minds. And that was the league's burden. But even putting aside the fact that it doesn't carry that burden, if you just look at what the 3 board members said, there's no reason to think that any one of them would have changed their mind if they had considered the aberration issue.
But isn't it significant that none of the 3 said one way or the other whether they believed that what happened in the Cargill case was an aberration or not?
No, Your Honor, because if you look at what they did say, if you look at the statements of members Oberman and Fuchs, These were two members who came on board, joined the board in 2019. That was long after the 2014 advance notice was issued, and became clear to them that they disagreed with a fundamental assumption on which the 2014 advance notice is based. Unlike their predecessors, they did not assume the validity of the 2007 fuel surcharges decision. Member Oberman thought that that case had been wrongly decided, and Member Fuchs thought that that was likely, although he didn't want to actually resolve that issue. So there's no reason to think that either of those two members would have been persuaded to change their mind by a ruling on the aberration issue. And the league doesn't explain why either one of them would have changed their mind. So for that reason, we believe that it would be speculative to think that a remand would cause any different result in this case.
Well, I guess I find it interesting that that would be the position that this agency would take. I mean, if an agency is supposed to undertake rational kind of review of things, and you had imposed a rule that seemed to not ultimately result in a reasonable rate, and the board, at least in one instance, and the board said, well, if this is the case consistently, this is a big problem that we need to do something about. And the board just sticks its head in the sand and refuses to even acknowledge whether it's a big problem, make a finding one way or the other, whether it's a big problem, and then doesn't do anything, says it can't really agree on a course of action to take. Hasn't the board just kind of at least fundamentally failed in kind of like kind of agency 101, because it's identified something that's a problem. It says we want to try to figure out how widespread it is, and then just like ducks the whole question and never even answers the question as to whether this is a widespread problem or not?
No, Your Honor, because as I said, two of the board members thought that the rules on which the safe harbor was based may have been either were invalid or were likely to be invalid. And so whether or not there was a widespread problem in terms of the aberration, in terms of the Cargill result, the kind of Cargill phenomenon, that would simply be irrelevant to what those two members preferred to do. So that's one issue, that's one problem. The other thing is that even if the Cargill result was not an aberration, there are other factors that would go into whether or not the board would repeal the safe harbor. And those are things that the board asked about in the advance notice. For example, in the advance notice, among the various things that it asked the parties to comment on was whether or not there were problems with the safe harbor that were outweighed by the benefits. So
I understand all that, but I guess my point is that they might do something that might save people millions of dollars. And even if it's not specifically repealing the safe harbor, that's giving them some relief to their injury, which means redressability.
Well, for example, Your Honor, if Member Oberman's view prevailed, the 2007 fuel surcharge decision would have been reversed, and railroads would be able to charge rate-based fuel surcharges. So it's not the case, it's not clear why addressing the aberration issue would have any effect on his preferred outcome. And Member Fuchs was very similar, very much along the same lines. He was very concerned about the validity of the 2007 fuel surcharges decision. So again, it's not clear why the aberration issue would affect how he would want to come out. And again, it was the league's burden to show that that it was likely that the aberration issue, a resolution of the aberration issue, would have changed the outcome of the board's decision. Now, I'm not saying
how does that square with what we've done in what we did in radio, television, and other cases where we granted, where we sent cases back where there was a denial of a petition to institute a rulemaking? We don't say that we're only doing this because we believe that well, I guess, and let me say it this way: for standing purposes, we assume that they win on the merits, right?
Right. You would assume that there was not an aberration. The Cargill result was not an aberration.
That it was not an aberration, and but we also assume that they would do something with respect to either getting rid of the safe harbor or amending it in some way to their benefit. I guess what I'm saying is you're making the burden on them higher than I think it should be for Article 3 purposes, that they somehow have to prove as part of the Article 3 analysis that they would ultimately win, but we assume that they win for the standing analysis, don't we?
No, for redressability, the burden is on, well, here the league to show that there would have been a different outcome if the board had addressed the aberration issue. I think that's their burden. And they haven't shown that it's likely that either of these two board members would have changed their mind and voted to propose the repeal of the safe harbor.
So you think that we should hold that where an agency doesn't seek to identify something that's a problem, but then doesn't seek to determine what the extent of the problem, and just says, we can't agree on dealing with this, we should find that it makes no difference, or that the petitioner has to show that if they had realized the extent of the problem, they would have done something differently. I don't think I worded that very well, but that the determination of the extent of the problem kind of doesn't necessarily have any impact on whether they would have acted differently in trying to resolve the issue.
Your Honor, I think it depends on the case. And usually, for example, on radio television, where an agency does identify a definite problem, then yes, the agency has to meaningfully address why it either thinks it is still a problem or is not a problem.
Didn't they do that in Cargill? I mean, we can look at the language in Cargill, and there's a whole bunch of language in there about, if this is indeed not an aberration, then we've got a problem.
Right, Your Honor. So that was the question. Is it an aberration? But the issue here is that two of the board members thought that the two board members who joined after the advance notice fundamentally disagreed on whether or not the advance notice was, they disagreed on a fundamental assumption on which the advance notice was based, namely that the 2007 fuel surcharge rules were validly promulgated. And if that view were to prevail, then the whole aberration issue goes away. It doesn't matter, because that's a fact-bound issue. And resolving that fact-bound issue isn't going to affect how one views that legal question of the validity of the 2007 fuel surcharge rules.
What's the fact issue again? Because I thought the distinction that you were drawing in your brief, maybe I'm misunderstanding your argument. I thought the distinction that you were relying on was that in radio television, the agency operated on the premise that there was a problem. In this case, because it's an ANPRM as opposed to an NPRM, there's a predicate question as to whether there's a problem in the first place. And,
yes.
And there wasn't a determination in radio television. Part of what fueled the court's decision, including its decision that it made sense to send it back, was that it was operating against the predicate that the agency had already said there was something to be fixed.
Absolutely, Your Honor. That's a difference. The agency said there was a problem. The agency actually proposed something to do about it and instead just left that proposal out hanging. That's not the case here. And the agency actually in radio television set up for itself a particularly high burden to explain why it was not going, if it was not going to do something about that problem, why? And here again, the board did nothing along those lines. The two cases are at different stages of the rulemaking proceeding. The board's here, the advance notice is much earlier stage, where we were trying to find out whether there was a problem that needed addressing in the first place.
And what's the factual issue you were just talking about in response to Judge Wilkins? I just want to make sure I understand that.
The aberration issue is essentially a factual issue. Is the Cargill type of phenomenon, was that a widespread phenomenon, or was it sort of a one-off? That's a factual issue. And the resolution of that issue is not going to affect someone who thinks that the fuel surcharge rules were inappropriate to begin with.
Mm-hmm. Which you say two board members had already reached that conclusion, or at least indicated in their
right. Well, one certainly had, and the other indicated serious concerns along those lines.
Mm-hmm.
Serious concerns doesn't mean, though, that they believe that the decision was wrong. I guess here's my bottom line here is that the Cargill decision says that if this isn't an aberration, then we've got a problem. And that's why you have the advance notice of proposed rulemaking. Do you agree with that?
It said, yes, if there's a widespread problem, then we need to think about whether or not we're going to do something, what we may want to do about that. Because even if it were widespread, there are other factors that may come into play as to why the board may want to either modify the safe harbor or retain it. There are a number of factors that would come into play.
But yet there was no undertaking to determine whether this was a widespread phenomenon. Agree? No
Yes.
finding.
Correct.
Okay. Let me make sure my colleagues don't have additional questions for you, Mr. Light. If not, we'll hear from Mr. Slover for his rebuttal. We'll give you 2 minutes.
Thank you, Your Honor. I have only two points to make. One, at page 27 of our brief, we deal with the question that Mr. Light has been dealing with in the Sullivan case. Essentially, he's saying that the commissioners don't believe in their own rules and regulations, and the decisions of the court require the board to enforce its own rules. And the fact that these two commissioners had misgivings about their own rules, totally irrelevant. Our case comes down to this. If, as we demonstrated, the railroads are earning hundreds of millions of dollars in profit from charges intended only to get fuel costs returned, they are engaging in an unlawful practice. The board's rules, its decisions, its regulations say that a charge that includes a profit is unreasonable and unlawful. Had they found that, as they had to with these thousands of pages of record, then they had no other choice but to issue a rule eliminating the safe harbor, which perpetuates and enables the overcharging. That's our case in a nutshell. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
This honorable court is now adjourned until Friday, February 5th at 9:30 a.m.
How much time do we have before conference?
Judge, the other judges have disconnected from this call. They cannot hear your question.
And how much time do we have before conference? Did you hear it?
Oh, I heard your question. I'm not sure because it depends on when